Hi Cyber Class. In this video I want to talk a bit about the Fisa statute and the changes to the Fisa statute made by the Patriot Act after 9/11. In the first video that I gave you for this week, we talked about that Eastern District of Michigan case which deals with the wiretap statute and the relation between the wiretap statute and national security. Now, there are a number of other authorities. We mentioned last week the warrant requirement. There are some other authorities through which the government can get electronic information in a criminal proceeding or regulatory proceeding. And we're going to come back to some of those other authorities in a few weeks when we move more into the skills part of the class. So the ECPA, the Pen Register, we're going to come back to those things. But we're going to talk about the Fisa statute now because that relates closely to our national security kinds of questions. And it also then will feed into, over the next few weeks, as we talk more about civil liberties. So we saw from the Plamondon case, the court being concerned about whether national security does something unique with the Wiretap Act. After 9/11, these questions became really important and really intensified, and there were changes made to legal authorities that allowed the government, infamously, to more widely electronically surveil, both internationally and surveillance that took in information about U.S. citizens without getting a search warrant or a wiretap order, with getting a different kind of authority, which was an order under the Fisa statute. So we're going to talk a bit about where does the Fisa statute come from and why was it changed after 9/11. And to do that, actually, we need to dig a little bit more into the U.S. national security framework and surveillance and espionage and law enforcement. So we need to look at the relationship between the CIA, the National Security Agency, and the FBI. So the CIA was established in 1947. Notice the Cold War era, right after World War II, which was the first peacetime intelligence agency in the U.S. And the CIA was organized in a statute created in 1949 that exempts the CIA from some budget reporting requirements. Now, why does it have that exemption? Of course, the CIA has to report generally its spending to Congress, but it is allowed to report some aspects of that in ways that don't reveal all the details, because the details, of course, are highly sensitive, highly classified, and the like. And so the CIA was primarily established for foreign intelligence gathering, for espionage, right, and spying, and activities relating to foreign intelligence gathering, particularly relating to human sources. The National Security Agency actually had its predecessors in the signals intelligence units in World War I and World War II, and the current version of the agency, established by President Truman in 1952, again, notice the Cold War era of the founding of the agency initially. And the purpose of the NSA is signals intelligence. Now, World War I era, that is still, flags and things like that, carrier pigeons, things like that, the beginnings of radio transmission, right? In World War II, it's semaphores and radio transmissions, and it's things like the Enigma machine. So all of those sorts of things, that electronic surveillance and signal decoding is the NSA. The FBI has its roots back in the 19th and 20th century of federal law enforcement. Now, the early establishment of the predecessors of the FBI in the 19th and early 20th century is quite controversial. If you maybe recall from constitutional law a little bit, there was a lot of concern among the founders about standing armies. Related to that, and not even on the radar screen, is the idea of federal law enforcement. So the general health and welfare, the criminal law, was really primarily thought of as a matter for the states, for the state police power. But of course there was some early federal criminal or quasi-criminal law. In the 19th and early 20th century, it was really the trust-busting kind of laws, antitrust laws, interstate commerce, things like that. And then with the growth of the Commerce Clause after the New Deal era and into the kind of contemporary era, we see the growth of federal criminal law. So the FBI was established for domestic law enforcement, in particular domestic federal law enforcement. So notice these distinctions, right? CIA, foreign intelligence, including human intelligence, that is spying. The NSA, signals intelligence. It could also include spying, but it's electronic stuff. And the FBI, domestic law enforcement. So there's a real concern in U.S. law and policy about the relationship among these intelligence agencies and the way they operate domestically. And the Flamandan case kind of illustrates, in one sense, some of that, because in the Cold War era, there's lots of government surveillance happening of U.S. citizens, including people like Martin Luther King Jr., heavily surveilled by the FBI on suspicion of being a communist and for other kind of harassment reasons and so on. So we didn't want, and really still don't want, the NSA or the CIA involved in domestic law enforcement. That's not the domain we think of as those agencies. We don't want the government ordinarily kind of spying on the citizenry. That's not a healthy state of affairs for a democracy, or at least it's not thought to be. So now the FBI, of course, engages in surveillance, but the notion is the FBI is doing domestic law enforcement, and if that's involving people within the U.S. persons, right, who are protected by the Fourth Amendment, and so the requirements of warrant and wiretap and all those sorts of things presumably would apply. So you have these distinctions or these silos being set up in the information that the CIA, the NSA, the FBI can share with each other for some very good reason, right? For the reason that we don't generally want information the CIA gets used in domestic criminal proceedings in the ordinary course of things. All right, so we have that as kind of our initial framing and our initial background. Now, the CIA, NSA are engaged in their international surveillance, their espionage type activities. The CIA in particular came in for a lot of criticism in the Vietnam War era. And as a result of activities of the CIA in the Vietnam era, the Church Committee, so Senator Church was the convener of this committee, investigated abuses of intelligence authorities, particularly of the CIA, in the Vietnam era and and before and after. And there were some pretty damning findings. I mean, the CIA really had instances when it kind of went rogue, when in fact the CIA was engaged in operations to assassinate foreign figures and foreign leaders. Assassination is unlawful under international law and crosses the line between really the fuzzy space of espionage in international law, which is very fuzzy. It's certainly, espionage often violates the national law of the sovereign in which the spying is being done. But there really isn't an international espionage treaty, so to speak. Everybody does it. Everybody knows everybody else does it. It's in a quasi-lawful, fuzzy space. Whereas the law of armed conflict in international law is well established in the UN conventions, as we have seen in cyber. So for the CIA to be doing assassinations on foreign soil is very problematic, and in particular, without any real oversight by Congress. So the Church Committee brings all this about. And as a result, the Foreign Intelligence Surveillance Act is one of the results of the Church Committee report. So the initial function, the initial role of the FISA court and of the FISA statute long predates 9/11, and it long predates the internet and all sorts of things like that. And it really kind of existed in a zone where not too many people even knew what it was or that it even existed. And so the idea is, even though the intelligence services, the CIA, the NSA, when they're operating abroad and engaged with non-U.S. persons, foreign citizens not on U.S. soil, the persons with whom they are engaged do not have U.S. constitutional rights. They don't have Fourth Amendment rights. Again, there's a possible international law concern. You're probably violating the domestic law of whatever place you're doing this in, unless it's an ally and you have some permission. But it's not a constitutional concern. So the idea of getting a warrant or a wiretap order wouldn't really apply. But what Congress thought after the Church Commission report is there should be at least some kind of check on that kind of activity. And so the FISA court provides that check. When there are certain kinds of foreign surveillance activities that the intelligence services want to take, they submit an application to this secret court. The court, by the way, is made up of sitting district and circuit court judges who sit specially by designation. If you look at the FISA webpage that I give you to look at, you can see who the judges are. So the fact that the court exists is not secret, but the proceedings are all under seal. The proceedings are all secret. The proceedings are not adversarial, right? So the government is just submitting an application. The court is looking at it ex parte. Obviously, you're not going to, tell some agent of a foreign government on foreign soil that you're going to be surveilling them, right? But it's at least some kind of, the ideas are at least some kind of check. So this court, exists really kind of without much knowing of what it's doing or anybody really being too concerned about what it's doing. 9/11 happens, obviously a devastating event in the history of the country, and after 9/11, the 9/11 Commission is formed to kind of determine how did this happen? How is it possible that these cells of Al-Qaeda are forming, and people are coming into the U.S. and are living and working here for years and are planning this whole thing, and actually managed to hijack 3 jetliners and successfully, crash 2 of them into the Twin Towers and 1 of them into the Pentagon. A stunning blow, obviously. And one of the findings was that it was a problem that the CIA, FBI, and the State Department, including the NSA, were walled off from each other. And that if these agencies had been able to communicate more about the information that they had, and if they had a little more free rein to gather certain kinds of information, that in fact this plot could and probably would have been foiled. And you're in this sort of wave of fervor and patriotism and so on, and this finding results in the Patriot Act, and the Patriot Act does a number of things, but some of the things the Patriot Act does is amend and create new authorities and broadened authorities under the FISA statute. So the FISA statute's going to be no longer just this sort of sleepy thing for certain kinds of foreign espionage activities, but it's going to encompass activities relating to surveillance of activities relating to terrorism, and the scope is going to be extended in such a way that it's going to be easier to gather information that involves U.S. persons without going through the process of a search warrant or a wiretap order or other kinds of process like that. And we'll look at there's a few key pieces that were changed and that the government then used to engage in a really wide-scale program of internet surveillance and cellular phone surveillance. With the phones, it was collecting metadata relating to calls that people were making with internet traffic. There was scanning of large volumes of international internet traffic. And most of this was happening without really too many people knowing exactly what was going on. There were civil liberties groups that were getting wind of some things and were probing some of it, but it was all classified. And when there were court challenges that were brought, the Clapper case illustrates this a little bit, that I gave you to look at. Courts were finding people didn't have standing because they didn't know whether they were actually surveilled, and they couldn't know whether they were actually surveilled because all of it was classified, and you weren't able to get that discovery in court because of the state secrets privilege, and so it was very difficult for civil rights groups to figure out what was going on. And this is when Edward Snowden disclosed huge dumps of documents about some of these programs to the Guardian newspaper, and then it became a big public thing. And at the end of all this, I'm going to show you some of the documents that Snowden had disclosed to the Guardian. Then there were other lawsuits, other hearings, various things happened. So some of these things came to light. Now, as you'll see, just about all of the authorities that were enacted right after 9/11 either have been repealed or allowed to expire, with a key exception, which is Section 702, which in an amended form has been extended. So we'll talk about that as we go through these things. So Patriot Act Section 215 allowed the government to collect tangible things, certain tangible things, not concerning a United States person. All right, so we're looking at this and we're saying, okay, this is pretty consistent with what the prior Fisa statute would have allowed, not a United States person, the Fourth Amendment doesn't apply, or to protect against international terrorism or clandestine intelligence activities. So here's a pretty, extraordinarily broad authority, which can allow the government to collect a broad amount of information that can also include information on U.S. persons. It required a court order, but again, the court order was from the FISA court, and it's a very low standard. It's not probable cause, right? It's just a showing that it's relating to a terrorism investigation, and it's all classified, and no one's ever going to get access to exactly what happened. So a court order is required, but the kind of showing the government has to make under the original version of the statute is quite small. So all the government has to do is specify the records are sought for an authorized investigation for the reasons we mentioned, including to protect against international terrorism. That's a really broad standard, very easy for the government to meet. What later turned out through the Snowden revelations and other revelations that came out, the NSA, the National Security Administration, was collecting bulk metadata of telephone call records, cellular call records, massive amounts of information, and then was using a process called contact chaining to query those records. So if they knew that, so-and-so was a known Al-Qaeda affiliate, and then through this metadata they can see that person contacted this person, and then this person had contact with that person, and so on. They would do multiple hops, and then look at and seek more information about a large amount of records. Now, as some of this information came out, Section 215 went through some different forms. So you see in the 2006 version, it somewhat tweaked the standard of what the showing the government had to make, tweaked a showing of what kinds of records might be allowed, And the FISA court interpreted this to still allow bulk metadata collection. So tweaked the statute a little, but really didn't significantly restrict what the government's authorities were at the time. One of the key things that the 2006 revision did do was to enumerate what kind of minimization procedures were required. And in fact, the FISA court had already indicated that some minimization procedures were needed when the government was collecting bulk data. And, what are minimization procedures? It just means, all right, this is what we have to collect, but in what ways can we limit the amount of information we're collecting, and in what ways can we limit the queries that we're going to make against that information. All right. Again, amended in 2015, and this amendment was to the kinds of queries that the government was allowed to make on the data that it had collected. And so now it wasn't just the minimization procedures in the collection and use of the information, but how specific the query term, selection term, had to be when you're looking for that information. And this was understood and interpreted to mean that the government can no longer do bulk collection. Now, by the way, one of the reasons all of this was, a little shocking or certainly very controversial was, all this to a large degree requires the cooperation of the service providers. So, of Verizon or, of Google, so on. And all these entities did cooperate. Now, of course, they were getting presumptively lawful process served on them, a court order served on them. And there were, issues about all of this being classified and so on. So their argument was they were limited in what they could do. But you really had this, government collecting bulk amounts of information from the service providers. And the 2015 revision did ban the bulk collection, but it did not require or limit the government's ability to query the existing stuff it had collected. 2018, the statute is reauthorized again with a bulk collection ban. By the way, these statutes, these authorities tend to, and all of these were passed with expiration points. The idea is the post 9/11 period is a period of emergency. And hopefully that period of emergency at some point ends, so these authorities would expire. But then the question is, well, how often and how long do they have to be renewed, right? And now you have it going on for almost 20 years. That's quite a long time to have a kind of extraordinary surveillance authority. Then in March 2020, it finally did expire and was not renewed via the sunset clause in the statute. So another key amendment in the Patriot Act Section 2 was Patriot Act Section 206, and the Section 206 was understood to allow for roving wiretaps if the suspect uses technology that would have the effect of thwarting an investigation. And if that were the case, then the wiretap order could, under the wiretap statute, could relate to multiple devices instead of being specific to one device. And the reason for this obviously was the notion that, well, the bad guys, particularly the very sophisticated terroristic actors, are good at switching channels. Whether literally technologically switching channels or switching devices or using burner phones, all sorts of things like that. And having to constantly go back and get a wiretap order is much more burdensome. The concern, of course, is it starts to look like a writ of general assistance. It starts to look like an open-ended wiretap, which is a real concern. So again, this one was allowed to sunset in 2020. Section 6001A of the Patriot Act was something that was called the lone wolf provision. The idea of the FISA statute and its ability to have surveillance authorities would be related to certain kinds of U.S. investigations or specific U.S. foreign relations activities or national security, concerns. And the amendments after 9/11, of course, then emphasized the issue of terrorism. And the lone wolf provision said, well, the individual, if it's a non-U.S. person who's going to be subject to this surveillance, doesn't even necessarily have to be connected to a specific terrorist group. So we don't necessarily have to know or have a connection that this person is affiliated with Al-Qaeda or with ISIS, but we think this person somehow or another might be involved in terrorism, right? And so this gives a really, again, a kind of another broad authority. There were allegations of abuse of this authority, in particular with the Muslim community in the United States. So, someone who really has no evident terrorist ties at all, but the government wants to surveil because of their connection to non-terroristic Islamic groups, things like that were problematic, and this again was allowed to expire in 2020. Now let's look at 702. So 702, as I said, is one of the one key authority that still exists in a modified form. It actually is set to expire the end of this year. And so our discussion this week will be about, should this be allowed to expire? Should it be reauthorized? Should it be reauthorized in an amended form? And what about the lone wolf provision? What about the other provisions? Should they be reauthorized at this point or not? All right, so 702 was actually part of the amendments in 2008 that made changes to Section 215 and other changes. So you have kind of changes being made on one end and then authorities being put into place on another end. Section 702 allows the government, for a period of up to a year, to target a person reasonably believed to be located outside the United States to acquire foreign intelligence information. So reasonably believed to be located outside the United States. Like most of these kinds of provisions, this had an exigent circumstance. As long as so that surveillance could begin if there was some thought of an emergency, so long as then the government went back to the Fisa court and got the necessary authorization. And this, like these other authorities, required internet service providers, Google, entities like that, to cooperate with these orders received from the Fisa court. And of course, since it's in the Fisa court, all of this is classified. Now, Fisa Section 703 allows a Fisa order that is targeting a United States person, right? So 702 is talking about a non-U.S. person reasonably believed to be outside of the United States. So presumably, at least as to the person outside of the United States, the Fourth Amendment doesn't apply, right? Even though, and this is where it gets interesting, even though the government is engaging with ISPs and other providers within the United States who presumably have information about that person who is reasonably believed to be outside of the United States. But here we have a U.S. person who undoubtedly has constitutional rights against the government. Reasonably believed to be located outside the United States for the purpose of foreign intelligence information and certain kinds of electronic information. So one thing this provision is doing is trying by statute to answer a question, which is a legal question, which is, you have a United States person within the United States, U.S. citizen within the United States, or a non-citizen on a proper visa within the United States, Fourth Amendment applies, right? How about a United States citizen who is abroad? and the United States government, and they're on foreign soil, and the United States government is surveilling them without a warrant in a way that in the U.S. might require a warrant. Do they have constitutional rights abroad? Well, this statute would suggest, right, that they don't. That the process that is proper here is only getting the FISA court order. And to get that FISA court order, the government has to show, a relatively basic thing, much lower showing than probable cause. Reasonable belief they're located outside the United States, and that person is a foreign power, an agent of a foreign power, or officer or employee of a foreign power. So, a U.S. person could be a spy working on behalf of a foreign government, or a U.S. person could be affiliated with a foreign terror group. So minimization procedures are required. The kind of substantive showing, significant purpose, is to obtain foreign intelligence information. That's a very low showing, obviously, much lower than probable cause, and that the information can't reasonably be obtained by normal investigative techniques. This is, again, it adds something to the showing, but it's not very hard for the government to overcome. Now we're going to look at some of the documents that were originally disclosed by Edward Snowden. And these documents raised concerns for a whole bunch of reasons. There is the kind of central legal question of if the United States government is engaging in surveillance that involves U.S. persons, whether it's a U.S. person on foreign soil, or whether it's a U.S. person who in fact is on U.S. soil, though the government reasonably believed they were on foreign soil, right? Where that U.S. person is engaging with a provider that is subject to U.S. jurisdiction, again, like a Verizon or a Google or something like that. So there's a core, constitutional concern and civil liberties concern. When the U.S. government is surveilling foreign persons who are, and the surveillance is happening through providers, ISPs and Google and so on, who are subject to U.S. jurisdiction, and that relationship, again, is another kind of set of concerns. When the U.S. government is surveilling a foreign person, and the foreign person is having contact with a U.S. person, and so then the surveillance is revealing the contact with the U.S. person, right? Those are basic constitutional concerns, and I think you can see how all those concerns connect with the issues raised in the Plamondon case, right? And again, what's happening here is the government's doing all this without getting a wiretap order, without getting a search warrant, with getting instead an order on a much lower showing in a secret court. So those were concerns, but also the scale of what the NSA ended up doing was, kind of shocking to sort of see in black and white. So I'm going to just quickly go through some of these documents so you can get a feel for it. And these were a couple of different programs that the NSA was running at the time. So, just note what the government's thinking about. And on the one hand, again, from one perspective, I think you can understand this. It's in the immediate aftermath of 9/11. It was a frightening time. And so you can understand why there is this desire, and to some extent a need to engage in certain kinds of surveillance. But, those circumstances always push civil liberties to the limits and sometimes beyond the limits. And so, as lawyers, we just are always thinking about, well, how does the law push back against this? When are we actually giving up the very thing we're trying to protect, right? So most of the world's communications, well into the internet era, flow through the U.S. Your target's communication, a foreign person, could be flowing through the U.S. This chart is just showing, bandwidth around the world. These providers are among those who were being subject to these kinds of FISA court orders and other sorts of process that the government was doing, and all these kinds of information you may get in this. This just shows different providers who are being subject to these orders. And remember, like Section 215, for example, you have bulk collection, right? So you're not. It's not like these are specific search warrants for individuals. This is bulk amounts of data. Just showing how the data flows through the government in some cases. This was really interesting because this graphic shows the intercontinental internet wires undersea, right, coming in and out of the United States, and the ways in which, as the wire is coming into the U.S., the U.S. is taking some of this information. The different email address books, things like that, buddy lists the government was getting, what to do if you have information on a U.S. person. So sometimes it could be used, sometimes it couldn't. This key score apparently was a system that was distributed around the world, all around the world, right? Here were sites where this system was distributed. Quite interesting to see. So there was activity the U.S. was doing on foreign soil, right? Which is a traditional thing, but just to kind of see the scope of what was happening. And again, look at these sites, right? These are places where there are intercontinental internet cables coming into the U.S. Let's see, different plugins that you could use in these programs, right? How to do selectors for different kinds of targets. Whoops. I thought this was quite interesting. Right, so you have all this data. You can query the data for something like, show me all the encrypted Word documents from Iran. You might get something back, or it might be too much, and maybe you need to narrow your query. But right, a lot of information coded in ways that could really be used. Show me all the VPN startups in a certain country. All the Microsoft Excel spreadsheets coming out of Iraq. All the exploitable machines in a certain country. Pretty extraordinary. Now, even though many of these authorities have been discontinued, and as we'll see in a moment, 702 has been significantly or modified, at least to some extent, right? The government still is doing a lot of this stuff. It's still doing all of this stuff in certain ways. It might be doing it under some different authorities. It might be doing more of it overseas than it's doing in the U.S. But it's doing all these things, and I would also say, don't kid yourself. Other governments are doing similar things as well. European governments and powers that are hostile to the United States. So the government has always claimed all along that these programs have resulted in the capture and arrest of a lot of bad guys. It's kind of impossible to verify that because the information is classified, and who knows how accurate that is or not, but the government has always claimed this. I do remember it was more than a decade ago, I had convened some working groups on cybersecurity and had like some round tables, and one of these round tables I had some government people, and there was a guy from the NSA at the round table, and he was kind of some mid-level person from the NSA. He's a really interesting guy, but he did say at one point, if we didn't have all these legal issues, we could keep everyone safe. And that to me was, real. And I said something snarky like, if we just didn't have the Constitution in the way, right? But it's one of those difficult things. I can understand the perspective of this person whose job it is to try to keep people safe, and that it feels frustrating to have the law stand in the way. But of course, the law to some extent has to stand in the way. All right, so that's just a little, really quick. And if you're interested in this, you can poke around and find more information about what many of those programs were. So now let's look at some of the more recent amendments to Section 702. So in 2018, Section 702 was reauthorized. One provision said it shall be conducted in a manner consistent with the Fourth Amendment. I have no idea what a provision like that is supposed to mean. You know, if the Fourth Amendment applies, it always has to be consistent with the Fourth Amendment. And if the Fourth Amendment doesn't apply, then the statute is simply providing some extra guardrails. So I'm not sure what that's supposed to mean. Limits the use of certain information about a U.S. person in a criminal proceeding. And this is potentially a big deal because otherwise there was not an exclusionary rule. You know, if Section 702 procedures hadn't been followed, and in fact it was often impossible for a criminal defendant to get discovery about FISA information because it's all classified. So this is an important limitation. And then limits what are called abouts collection. So remember when I said, like, let's say you have someone who's a known ISIS agent and who is a foreign person, and you're gonna, collect information about that person, which can include steps that go beyond that individual person and might slurp in other information as well. And so this provision limits the abouts collection only to certain kinds of emergency exceptions unless there's a specific further approval by the FISA court and a review by Congress. So potentially that's a limit on sort of the ultimate, scope of who is actually being targeted, in particular about whether a U.S. person is going to be slurped into it. So as I said, the sunset provision is the end of this year, and I haven't really recently seen too much discussion about whether it's going to be reauthorized or not. I suspect, within coming months we will see some more discussion about it. There was, when it was last reauthorized by President Trump, under the Trump administration by Congress, there was some question about whether President Trump would support it. I gave you to look at his signing statement. Signing statements occupy a really ambiguous place in the law. The Constitution only says that the president can either sign or veto a law. So, but sometimes courts give signing statements some degree of interpretive weight. It's a gray area. So you can take a look at some of the concerns that the Trump administration had raised, and we'll see what happens with this in the Biden administration. This graphic just shows the existing process or flow through which Section 702 is used, and this is put out by the government, so it's an effort to show, hey, we're really, this is reasonably robust. The court reviews things carefully. Like some of the things we saw before, the government claims that this has really protected the U.S. from Al-Qaeda and ISIS and cybersecurity threats and so on. Hard to know to what extent that's correct. This slide is a government flowchart of what are called the Woods procedures. And that's named after, I presume, the person who came up with the procedures. But this is just the flow, the procedures the government internally uses. And so the purpose of the government showing us this is to say, there are multiple places before the application is ever submitted to the FISA court that it goes through kind of internal stages of review. And then, of course, when it's submitted to the FISA court, there's the review by the court. I had a guy a colleague who used to lecture to our course once in a while when he used to be the head of cyber in the FBI in Newark. And he had testified before the FISA court and had his view was it's really robust and internally they go through a big process. So that was interesting, and the government still says, the security authorities who really believe they need 702 still say these procedures are robust. There's some question about this. I also gave you to look at the most recent Office of the Inspector General report, which was an audit prompted by an investigation under the Trump administration about the Trump administration's complaints about the Russia hacking issue and the Steele dossier and all that stuff, if you remember all of that stuff. And the audit found that the Woods procedures were often not being followed, which would be a real concern, obviously, if this is the kind of thing that the government is saying it helps protect us. So the question we're left with is, should 702 be re-upped? Should any of should Section 215 in some form be reauthorized? Or should all of this be allowed to expire? And in which case, FISA would go back to sort of its old, much more limited role. And if the government is going to try to collect information of the sort that it's been collecting here, it's got to use much more targeted process involving search warrants and wiretap orders and maybe ECPA orders. So those are the things to think about this week.